Hello everyone. Welcome to the session on Karmayogi Ias. I hope I am audible to everyone in this session. Basically, the agenda of this session is to move further with our test series discussion. Previously, we had a discussion on the test series part 1 for polity. That is, I discussed 50 questions previously. Now in this session, what I am going to do, I am going to record and provide you the explanation for the remaining 50 questions. Okay. So without any further delay, let's move ahead. I hope my screen is visible. So first and foremost, the last question we discussed previously was related to judicial activism. In test 1, moving ahead, the 51st question was related to Pitt's India Act. So this particular question talks about certain statements about Pitt's India Act, that it is also known as Act of Settlement. Statement number 2 says it established a double government. Statement number 3 says the company's territories are first time called as British possessions in India. And the fourth statement says it made the Governor General of Bengal as Governor General of India. Now, the question says how many of the above statements are correct? So, my dear aspirants, I'd like to tell you in this question only two statements are correct. Statement number 2 and statement number 3. Because if you read the explanation carefully, you'll find out that Act of 1781, the amending act, which was before the Pitt's India Act, that is called as the Act of Settlement. And the Charter Act of 1833 made the Governor General of Bengal as Governor General of India, not this particular act. Okay. So considering this fact, only two statements are correct. So you should be very well aware of the fact. These kind of questions are generally asked in the examination. Okay. Question number 52 is Global Partnership on Wildlife Conservation and Crime Prevention for Sustainable Development. It was in news in 2023. That is why this question has been framed by us. Led by which of the following international organization? Generally, questions like these about international treaties, conventions, international partnerships, they are in the news and they are bound to be asked by UPSC. You all should be aware that these kind of questions will be coming. So this particular question answer is World Bank. World Bank is the leading organization of Global Wildlife Program. Okay. So you should be aware of the fact that this is the correct answer for this particular question. Okay. Moving further ahead, as we move on to the next question, question number 53 talks about with reference to major judicial pronouncement of post-independent India, consider the following statements. This talks about certain cases that are given in your Lakshmikant book directly. And this is a direct question, I'll say. If you people must be aware of the information in Lakshmikant, many of you will be able to solve the question. First statements talk about Champakan Dorai Rajan case. That the ruling was DPSP have to conform and run as subsidiary to fundamental rights. This is the keyword. Try to find out the keyword in every question. Statement number 2 talks about Keshwananda Bharati case. It held that Indian constitution is founded on bedrock of balance between FR and DPSP. And the third statement is about Minerva Mills case, where the Supreme Court ruled that fundamental rights under Article 14 and 19 were subsidiary to DPSPs mentioned in the Article 39B and C. How many of the above statements are correct? Now here you have to find out the correct alternative or the correct statement. So in this particular question, only two statements are correct. Why? Because statement number 2 is incorrect. Keshwananda Bharati case, if we talk about it, upheld the validity of Article 31C. Okay, it inserted and under this particular, it declared that 31C is 1C2, which sought to restrict the scope of judicial review, is unconstitutional. It did not talk about the bedrock of balance between fundamental rights and directive principle. The bedrock of balance between fundamental right and directive principle was discussed in Minerva Mills case. So this particular statement relates to statement number C or statement number 3. So when you are aware of Minerva Mills case, you will instantly find out that statement number 2 is indirect or it is not related to Keshwanand Bharati case. Okay. So in this particular question, only two statements are correct, and that is statement number 1 about Champakam Dorai Rajan case and statement number 3 about Minerva Mills case. Okay. Question number 54 of the test talks about International North-South Transport Corridor. This corridor is in news recently. Our Prime Minister also talked about this. That is why the question has been framed. Okay. Always be aware that anything which is in news, which is a debatable topic, which relates to certain recent development, that might come in the examination this year. So you should have a keen interest about these topics. Okay. First statement says that its foundation was laid by India, Iran, and Russia. Okay. This is correct statement. Second statement, its primary objective is to build air connectivity between India and West Asia. Only air connectivity? I don't think so. So this statement per se is wrong because it is a multimodal corridor. Multimodal means it has shipping routes, it has road, it has railways, it has air connectivity. So any corridor, apply your logic here. Do you think that a corridor which is involving so many countries, which is so big, will only be dealing with air connectivity? And mostly if a corridor is related to trade and transport, will that only be relying on air connectivity? No, that will be having multimodal connectivity. That will be having roadways, shipping, railways, air connectivity, all the things together. So statement 2 is wrong. It originates from Mumbai in India. So talking about India, it is starting from Mumbai itself. So the third statement and the first statement is correct. The second statement is wrong in this. So only two are correct. You should read these explanations very carefully. They have been framed in such a manner that they will give you good information about a particular question and its solutions. And these explanations will be helping you out to have some value addition. If you people are not aware of certain things which are given in the explanations, please make a note of them. These notes are going to help you for value addition in the examination, and they will also enhance your content in the coming time. Okay. So make sure you are doing that. Let's move ahead to the next question. That is question number 55. Which of the following procedures can be amended by special majority of parliament and consent of the state? A special majority of parliament and consent of the state. That means these provisions which require consent of the state also along with a special majority must be dealing with certain federal features. Whenever states are involved, you have federal features related to them. Election of the president, yes, correct. Both state governments are involved and central government people are involved. Okay, admission of new state, establishment of new states, no, that is done by simple majority. Representation of states in the parliament, again, some federal feature is involved here. Okay, use of official language, no, nothing federal. Okay, so statement number 1 and statement number 3 directly relate to this. Okay, so moving further ahead in this particular question, what we will discuss. 56 says, consider the following statements about Forum for India-Pacific Island Cooperation. This forum was in news. Last year, its summit was held on 22nd May. That is why this is in that is why this question is asked, and you should also be prepared that in examination also these kind of questions can come. It is a multinational grouping for cooperation between India and 14 Pacific Island countries. Correct, but obvious it is a multinational grouping, right? Next thing, it was launched in 2016. Okay, now this is a catch here, whether it was launched in 2016 or 14 or 15. So this is a factual information which you people should be aware of. Third is, recently 7th summit is held in Port Moresby, the capital of Papua New Guinea. How many of the statements given above are correct? So statement 1 is correct. Yes, it is this when we talk about this, it is a forum for cooperation between India and 14 Pacific Island countries. It was launched in 2016. Incorrect statement. It was launched in 2014, not 16. Because it is a factual information, you people might have found this question tough to deal with. And lastly, recently 7th summit held at Port Moresby, Papua New Guinea. This is again incorrect because I'll tell you, third forum for India Pacific Island Cooperation was held at Papua New Guinea, not 7th. It was a third summit. Again, a factual information. You should be ready for these kind of questions which deal with factual information. Question number 57. Consider the following statements regarding the passing of an ordinary bill in the parliament. In first stage, a bill is introduced in the house and detailed discussion will take place. If you people have gone through the billing process, read the Lakshmikant well, you people will be able to figure out this statement instantly, that in the first stage, detailed discussion cannot take place. This stage is only for the introduction of the bill. It is just for publication in the Gazette. No discussion can take place in first stage. So this statement is wrong. In the second stage, bill is referred to as select committee. Correct. It can be referred to select committee. It can be referred to joint committee for scrutiny. Discussions can take place. All these things are done in the second stage. Third reading, the debate is confined to acceptance or rejection of the bill as a whole, and no amendments are allowed. Again, this is correct. The third stage of the bill, when we talk about it, look, it is given also. This is confined to only acceptance or rejection of the bill. There are no amendments allowed. Bill is scrutinized in the second stage, and this stage is only used for passing the bill in the House. Okay. It is authenticated by the speaker or the chairman, whosoever is there. Thereafter, it is a bill is deemed to be passed by the both the houses of parliament. Okay. So you should read these explanations very carefully. Coming to the next question, consider the following statements regarding fundamental rights. Okay. Now, this question says they are meant for preventing the establishment of authoritarian and despotic rule in the country. Absolutely correct. If you read the fundamental right, the essence of fundamental right lies in the fact that they are meant to give political democracy and political rights to the people. They are meant to protect the people from authority, anarchy, and totalitarian rule. So this is correct. Second statement, the parliament cannot amend any of the fundamental right. Now, this particular statement, parliament cannot amend any of the fundamental right. This is a very extreme statement. So don't you think that these kind of extreme statements may be incorrect in examination, because parliament can amend the fundamental right. It is already given. It can repeal them, but not the basic structure. So I will again emphasize this point. Only basic structure cannot be amended. Okay. Rest, it can repeal, it can amend, modify, or it can curtail any of the fundamental rights, citing certain exigencies or citing any exceptions. Okay. So you people should be aware. Many of you must not be aware that whether fundamental rights can be amended or not. They can be curtailed, they can be amended, considering the fact that it is in the interest of the nation. Okay. So make sure that you people are aware of this fact. Okay. Moving ahead, consider the following statements. The proclamation of national emergency, external emergency, it is given in the bracket. Always be very attentive while reading the question. Proclamation of national emergency or external emergency automatically suspends the fundamental right under Article 19. Correct. Okay. If you read national emergency chapter, you will be aware that this is correct statement. Further, Article 359 authorizes the president to suspend the right to move any court for enforcement of fundamental right. Correct. Explanation and statement of number 2 is both are correct. Means both statements are correct and statement 2 is not explaining, because they are separate statements. Generally, in these kind of statement, try to read in continuation both the sentences. If there is some interlink or the statement number 2 is linked with statement number 1, then you should say that statement 2 correctly explains statement number 1. But if there is no connection between the statement, but both of them in their place are correct, you need to tell that both the statements are correct. Okay. Now, question number 60, when we talk about which of the following bodies have been constituted under provisions of Article 263. Now, Interstate Council, Central Council of Health and Family Welfare, Central Council of Local Government. If you have read Interstate Council chapter in your Lakshmikant, you will find out that all these are given in that. So Article 263 generally deals with constitution of Interstate Council. So all of the above are correct statements. It is self-explanatory. Consider the following statement. Next question. The Council of Ministers in Union of India is collectively responsible to both Lok Sabha and Rajya Sabha. This question is very simple question. I'll say this can be solved even with a basic common idea. If you have read the Lakshmikant and you have gone through any lectures of polity at least once. Council of Ministers or our executive is responsible only to Lok Sabha and not to Rajya Sabha. The essence of parliamentary democracy lies in that the executive is responsible to lower house or the popular house of the people. Okay. So this is incorrect. So automatically we'll get the answer A is false, but R is true. Okay. No need to go for the second statement also. You'll find out the correct statement from here. Next question, which is common to the places known as Sualkuchi, Pochampalli, and Paithan. Okay. Now, if you people must have read it in NCERT or somewhere, Pochampalli is very famous for silk. Paithan is also very famous for silk. So these are silk centers. Sualkuchi is in Assam. Assam is very famously known for silk production. Pochampalli in Andhra Pradesh is also known for silk production, and Paithan in Maharashtra is also known for silk production. So you should be aware of this. Look, in explanation also, we have given certain major centers of silk production. You people should memorize them, just go through them once, because these kind of questions randomly might be asked. And these are the questions where you can score certain brownie points, because many will not be able to answer these kind of factual things. Okay. Next question talks about public interest litigation. Now, public interest litigation, you must be knowing that this was brought about in 1980 in order to deal with certain social malaces and social issues. This question talks about that. First statement says it can be filed only by the aggrieved party. The essence or the basic agenda or basic objective behind PIL was that it can be filed by anyone. Locus standi, as the legal word goes, locus standi means the aggrieved party, or by what authority somebody is filing a particular petition. It was removed by PIL clause. When public interest litigation came into action or came into the mainstream, it was given that anybody can file a PIL in the interest of the society. That is why it is public interest litigation. So first statement is incorrect. Suo motu PIL by Supreme Court is not allowed. It is again a wrong statement. Even you people must be reading news and all. You must have come across various Supreme Court judgments where Supreme Court judges have themselves taken up any serious agenda or serious public issues, and they have given judgment upon them. So that is called suo motu judgment or suo motu verdict. Like in case of Delhi, around 5 to 6 years back, when there was too much issue around pollution of Delhi, cracker burning, Supreme Court itself took up the case and it ruled that in order to solve this pollution crisis, crackers should be banned. So this was a case. So this was an example of suo motu PIL. Okay. Moving ahead. Question number 64 talks about citizenship. Consider the following statement about citizenship in India. It is mandatory for any individual who wishes to become a naturalized citizen to take an oath of allegiance to Constitution. Very true. That is given in your chapter. That is a direct question. Commonwealth citizenship was removed by Citizenship Act 2003. Again, this is a correct statement. So this is a straightforward question. Commonwealth citizenship was removed. Every person who is a citizen of India, okay, by virtue of being a citizen of India, have the status of Commonwealth citizenship in India. But this provision was repealed previously. In 1955 Act, it was there, but 2003, from there onwards, we have only Indian citizenship. Okay. Next question talks about ordinances. Okay. This is a very burning topic, very debatable topic, often in news. So question number 65 says, the repromulgation of ordinance with the same text without any attempt to get it passed by legislature is liable to be struck down by judiciary. Very correct. This is really very correct. And then read the second statement in continuation. Why? Because the ordinance making power of governor is not parallel power of legislation. Again, I'm repeating, repromulgation of ordinance without any attempt to get it passed by the legislature or parliament is liable to be struck down. Why? Because it is not a parallel power of governor or president in that case. Okay, because he also has the ordinance making power. So if you read both this statement in continuation, you will find a kind of interlink between the two statements, that they are interlinked. So both the statements are correct, and statement 2 is the reason for statement 1, or statement 2 is explaining statement 1. So if you read them in continuation, you will find out that statement 2 and 1 are interlinked. That is why its answer is A. Okay. Consider the following statement about polar amplification. Polar amplification, it was in news recently last year in like in the month of September or October. It was in the Hindu also, the Indian Express also. That is why the question has come. This question, I'll say, is a bit tricky and complex. It is a kind of technical question from geography. Many of you must not be aware of it, but if you have solved it incorrectly, please try to go through explanation and please try to read about polar amplification from your books, from internet, from any good resource you can find, because you can find these kind of question. Polar amplification, polar vortex, about climatology, anything which is there in news and which is often quoted in the newspaper, you should be aware of it. Okay. Now, statement one says, warming differential between poles and tropics is known as polar amplification. Warming differential. Okay. This is a correct statement. Heat transfers from tropics to the poles through prevailing system of air circulation. Yes, due to this, there is heat transfer from tropics to the poles from prevailing air circulation. And third is polar amplification is much weaker in the Antarctic than in Antarctica. This is a wrong statement. Why I will tell you, because the concept of polar amplification itself says that it is stronger in the Arctic due to presence of sea. When sea is there, sea ice is there, it will give more thrust, more a frequency to polar amplification, because the differential will be high between poles and tropics. When sea ice is at a very higher level, at a very intense level, it will give more differential to temperature or warming between pole and tropic. That is why polar amplification is weaker in the Antarctica and stronger in the Arctic. Again, I'm repeating, it is stronger in the Arctic than compared to Antarctica. Okay. Next question is talking about Constitution of India. President's rule cannot be imposed in a state as long as Council of Minister in state, read the word, enjoys the confidence of lower house of or legislative assembly. Okay. Now, this statement is directly from the book again. It cannot be imposed in a state as long as Council of Minister in state enjoys the confidence of lower house. Now, reading about this question, you will find out that this particular question, if you see that only when president receives a report, okay, from the governor, he can do that. Or in case when the state government is enjoying majority, okay, then this is not the case. Suppose even the confidence it is enjoying and the council of minister is having confidence, but the president has got a report from the governor, only then also he can impose president's rule, because article 365 is also there. Article 365 says that if a particular council of minister or a government of the day, it is not following the directions given by the center, certain executive direction, then in that case president can impose a president's rule. So this is incorrect. Okay, coming to second one, any decision on loss of confidence of legislative assembly in council of minister by governor can only be made after allowing an opportunity to council to prove its majority on the floor of the house. Means suppose any particular council of ministers is not enjoying a majority, then it should be given an opportunity by the governor. So it is a correct statement. Any law made by parliament or president during period of president's rule ceases to be in force after 6 months from the date of revocation. No, it does not cease to be in force. It is in force. The state government or new government which comes to the power, it has to repeal that law, modify that law, or amend that law. Then only it will be stopped or it will be null and void. Or else anything done during president's rule, any law made by parliament or president during president's rule, it will continue to be in force. Fourth is any point of time president may revoke president's rule and revive a dissolved assembly. This is totally incorrect. He cannot revive a dissolved assembly. Use your logic and common sense in these kind of statements. If an assembly is dissolved, there has to be fresh elections. If any assembly is suspended, okay, in that case he can revive it. But suppose that assembly in itself is dissolved totally, how can a president revive that without elections? That will not be a parliamentary democracy, right? The essence or the basic agenda, this basic core of parliamentary democracy is that if a particular assembly is dissolved, if a parliament is dissolved, new election has to be held, right? So that is why this statement is incorrect. Coming to the next question, question number 68. It again talks about Constitution of India. It is a very basic question. The Constitution of India is lengthiest of all written document in the world. Point number one. This is correct. Why it is the lengthiest? Because it contains not only fundamental principles of governance, but also detailed administrative provisions. Now both the statements again are interlinked. I will tell you one more trick to solve these kind of questions. When you read statement number 1, ask yourself question why. Okay. When you read statement 1, after reading statement 1, just hide statement number 2 and ask yourself why. Okay. Then you read statement number 2. If the statement number 2 gives you the answer for this why, that means statement number 2 and statement number 1 are interlinked. This is a trick. So let's try it once. I will try it with you. Okay. The Constitution of India is lengthiest of all written constitution. Now I'll ask why. Okay. Because it contains not only fundamental principles of governance, but also detailed administrative provisions. You got the answer. So both statement 1 and statement 2 are correct. Statement 2 is the correct explanation for statement number 1. Okay. So you have got the answer for why. Now this way you will be able to solve these kind of questions. Now that is match the following. First is 75 by 25. 75 by 25 was a strategy by Ministry of Health and Family Welfare for people suffering from non-communicable diseases like blood pressure, hypertension, diabetes, sugar, that by 2025, they will provide care, our government will provide care to 75 million people. So first option is correctly matched. IDEX is related to defense exercise. It is a kind of defense exercise or what we call to provide self-reliance to our defense MSMEs. It has been provided. Okay, defense initiative. Sagar Parikrama initiative is of Ministry of Fisheries, Animal Husbandry and Dairy. It was a sub scheme or sub part of Matsya Sampada Yojana, where our government tried to improve the lifestyle and livelihood of the fishermen community, provide them economic prospects going further, provide them employment, and it has been merged with Pradhan Mantri Matsya Sampada Yojana. So this is also correct. Next question is talking about, it is a very direct question. Which of the following right is not included in right to equality in Indian Constitution? Prohibition on discrimination on the ground of religion, Article 25 to Article 15, sorry. Rights of the accused and convict. This we have not heard of. Abolition of title, it is Article 18. Equality of opportunity in employment solution. Okay, Article 16. Now, this are a right of the accused and convicts we have not heard of anywhere, because rights of accused and convicts, it is nowhere given in any article of the fundamental rights. Okay, it might be a legal right, but it is not a fundamental right. So this particular statement is not included in right to equality. Okay, so this is also wrong. Right to equality only is Article 14 to Article 18. Okay, Article 14 to Article 18. You should be aware of this. Then we have further right to life related provisions. Then we have right to religion related, freedom of religion related provisions. Then we have cultural and minority right related provisions from Article 29-30. So there are broad divisions of our fundamental rights, which is given on page 1 of your fundamental rights chapter. Please go through them. Question 71 says, the Prime Minister of India at time of his or her appointment. This is related to qualifications of being a Prime Minister of India. Okay. Must be a member of Lok Sabha. No, Rajiv Gandhi was not a member of Lok Sabha when he became the Prime Minister. Okay. So this statement is not correct. Must be a member of Rajya Sabha. Again, there have been examples where people have not been member of Lok Sabha or Rajya Sabha and became the Prime Minister. So this is also incorrect. He should not be a member of one of the houses of parliament, but must become a member of one house within 6 months. This is correct statement. Statement number 3 is correct. He need not necessarily be member of one of the house of parliament, but must become member of Lok Sabha within 6 months. It is only talking about Lok Sabha, but he can also become a member of Rajya Sabha, either houses. There have been prime ministers who were member of Rajya Sabha also. Manmohan Singh, Indira Gandhi. These are two such examples which I remember for now. They had been members of Rajya Sabha and were the prime ministers of India. So statement number 3 only is correct. All the other 3 statements are incorrect. Okay. Now, this is a kind of philosophical question. With reference to constitutional government, consider the following statement. So, talking about constitutional government, it is saying it places effective restrictions on the individual liberty in the interest of state authority. I would say that restrictions on individual liberty. Do you think that a constitutional government will put restrictions on individual liberty? I would not say so. That is not correct. Second is it places effective restrictions on authority of a state in the interest of individual liberty. This somewhat is correct. This is looking correct on the face value. It provides unrestricted powers to the central government. If it provides unrestricted powers to central government, it will become a totalitarian government or a monarchy or authoritarian government. This is not the feature of constitutional government. So statement number 3 is also incorrect. So statement 1 is incorrect, statement 3 is incorrect. So only one effectively is the correct for this particular question. Moving to next question. Select the constitutional duties of chief minister from the following by using the code given below. Now, this is very straightforward. Chief minister communicates to governor all decisions of council of minister. Chief minister communicates to the governor the proposal for legislation. He participates in meetings of Niti Aayog. Now, Niti Aayog meeting is not a particular the constitutional duty. It is a legal duty. It is not a constitutional duty, okay? Or it is not a kind of legal also, I would say, I beg your pardon. It is a kind of convention that has developed because Niti Aayog requires participation of chief ministers, okay? So all other are constitutional duties. Participation in Niti Aayog meeting is not a constitutional duty. So only 3 are correct statements. Question number 74 says is related to certain regions in news. Now, I'll tell you places in news, mapping, these kind of question are the questions where you can score very well because many people ignore these kind of facts. Now, these kind of questions will give you very good amount of brownie points or what I would say an advantage over those aspirants who will not be able to solve this. These kind of questions can give you 2 additional points. So if you are able to solve these questions very well and good, this may increase your prospects of qualifying the prelims very well. Okay. First is Kerkena Islands. Now Kerkena Islands was in news. It is in Tunisia, east coast of Tunisia. Then Murmansk. Murmansk is in Ukraine. No, it is in Russia. Okay. Look, it is given here. Dnipropetrovsk. Dnipropetrovsk is a city on Dnieper River in Ukraine. So these 2 are incorrect. Yanomami is in Brazil. Yanomami is in Brazil, so you should be aware of it. So this is factual. I would say that it is difficult for you people to handle these kind of question, but such factual question, if solved well, if you have heard of in the news, then this is going to give you a good advantage over other people. Okay, so only 2, Yanomami and Kerkena Islands is correct. Other 2 are incorrect. Moving on to next question. With reference to sedition law, which of the following statement is incorrect? It was a part of original Indian Penal Code enacted in 1860. I would say if you have read newspapers these days or in the last few months or last few years, you will find out that it was originally drafted by Thomas Macaulay. Because we always say that the sedition law is of British origin and Macaulay's Minute or Macaulay's Code which came that brought in the sedition law. So Thomas Macaulay omitted it in Indian Penal Code, but it was later added in 1870. Okay, so these things are in news often, so you must be aware of it. So this is the incorrect statement. Rest other statements are correct. Okay. Question 76 talks about republic. Consider the following statements regarding the term republic as envisaged in the preamble of the Constitution of India. Point number 1. Source of all authority under the Constitution is the people. Point number 1 says republic, source of all authority under the Constitution is the people. Point number 2, citizens enjoy equal status. Point number 3, all offices of the state are open to citizens. So basically in our preamble, the term republic is given. Now this questions wants you to know, okay, that which of the particular statement is incorrect. Means where do we find that the term republic is not connoting any of the 3 statements or whether the republic is connoting all the 3 statements. So only 2, citizens enjoy equal status. When we talk about republic government do not show equal status because it is not related to this concept. Republic means source of authority is the people. Republic means people have certain civil and political rights. Republic means that the government of the day draw their authority, draw their legitimacy from the people. It does not means that citizens enjoy equal status. It is equality which is given in the preamble, which provide or which connote that everyone is equal. Okay. What is the difference between vote on account and interim budget? The next question. So the provision of vote on account is used by regular government, while the interim budget is a provision used by caretaker government. Now I will tell you this statement is wrong. Even if even if the permanent government is there, then also they can use interim budget. It is not the thing that only caretaker government will be able to do the go for the interim budget thing. It is the permanent government also that can utilize interim budget. Generally, what happens, interim budget is brought in the election year when the elections are taking place. In that particular case, interim budget is brought about because in that year elections are going to be held. So it is generally advisable that the government which is re-elected or government which is again elected newly, that brings in the new budget rather than the government which is outgoing. Okay, that is why a vote on account only deals with expenditure in government budget, while interim budget includes both expenditure and receipt. That is true. Okay. Question number 78. When we talk about question number 78, it is dealing with judiciary. Whenever there is potential conflict of interest, a judge can take decision to recuse or withdraw from the case as it rests solely on the conscience and discretion of the judge. Okay. Why? Again, these are statement based questions. So I told you in the previous one, you should question why. Why this statement? Because India has no codified rules governing recusals. So when there is no codified rule, it rests on the conscience of the judge, the discretion of the judge, his ethical responsibility that he should recuse from a case if there is a conflict of interest. So both the statements are correct, and statement 2 is the correct explanation for statement number 1. Okay. There is no codified law for this. Often we come across news where we find any judge of high court or any judge of supreme court recusing himself. Recusing means he is willing to give up that case and want someone else to replace that bench because he feels that there is kind of conflict of interest, there is ethical dilemma involved in that case. Okay. With reference to Constitution of India, consider the following pairs. Now this is related to union list, concurrent list and state list. So cyber laws. Cyber laws in the union list. No, cyber law is in the residuary list. This is wrong. Whether state law deals with land? Yes, state law generally deals with land, agriculture, and property. Concurrent list, trade unions. Okay, this is also correctly matched. So this is a factual question, I would say. If you people are aware about the three list, you must have read about the three lists, you will be able to solve this. Certain other subjects in union list is war and peace, naval and military, air force, foreign jurisdiction, citizenship, naturalization, aliens. In a state list, agriculture, police, prison, local government, public, land. Look here, it is given. Concurrent list, education, transfer of property, forest, trade unions. Residuary parts are certain which are not mentioned in any of the list, which are coming as and when the requirement comes. Artificial intelligence, cyber laws, digital related things, all these are in residuary list. Okay. Next question, question number 80. Which of the following aspects is concretely applicable to the concept of doctrine of popular sovereignty? This particular question wants you to tell that which of the given statement is most closely related to the doctrine of popular sovereignty. Popular sovereignty means a government which is ruled by the legitimacy of the people. Popular sovereignty means the government has the confidence of the people that is right is ruling. Okay. Establishing a government rule through constitutional means, this is not very closely related, although it is somewhat looking very close. Establishing check and balance among the organs. This is separation of power. Establishing the authority in a state with consent of the people. What I told you, popular sovereignty means legitimacy of the people, faith of the people, trust of the people. So this statement to some extent is most closely related. Direct participation of people in government decision making? No, this is a tool of elections. This is nowhere related to the concept of popular sovereignty. Okay, so I would say that this statement is not correct, and the only correct statement, the most closely related one, is the statement number C. Okay, you should go through the explanation, it is written here. Coming to question number 81, it is talking about delegated legislation. Now, delegated legislation is a case where some amount of rules related to any law, any bill, certain regulations related to any law, any bill is given to or devolved to administrative departments, ministerial departments to be framed in a comprehensive way. Okay, so let's look at the question. The parliament authorizes executive to exercise this power only in exigent circumstances. No, this is a very common practice that has developed in our democracy, that if any law is framed, any particular bill is passed, then departments related to any ministry or the administrative departments which are related or will have to implement that law, they will frame certain detailed rules related to that particular law or bill. Okay, so this statement is wrong. It is not given in exigent or exceptional circumstances. Delegated legislation is a very common practice. The executive can make changes or expand the scope of rules and regulation as per administrative need beyond the parent law. This statement is also incorrect. It cannot make detailed changes or expand the scope of rules beyond the parent law. This is very common sense based statement. If you use your logic here, you will be able to solve this particular statement very easily. How can a particular rule override or go beyond the parent law? If something is written within the confine of a parent law, how do you believe that rules can go beyond that? Rules can bypass that jurisdiction? No, they cannot. The rules have to be framed within the confines of that parent law. Only then that will be legal. So statement 2 is also incorrect. The growth of delegated legislation has enhanced the powers and influence of the bureaucracy. Very true. Because if a particular law is framed and the detailed rules, comprehensive guidelines are made by the departments, then who is ruling the department? The bureaucracy. The bureaucrats are ruling the department. So that is why statement number 3 is correct. Look, the following factors are responsible for ineffectiveness of parliamentary control over delegated legislation. It is given also here. Parliament has neither time nor expertise to control administration, which has grown the volume as well as complexity. As a result, if a law is made, the detailed rules and regulations are delegated to the administrative departments. That we have made the law, now it is your responsibility that you frame the detailed rules. The legislative leadership lies with the executive and it plays a significant role in formulating policies. Growth of delegated legislation has reduced the role of parliament in making detailed laws and increased the parliament powers of bureaucracy. So this is directly the statement number C which was given. So you should go through these explanations. They are going to give you some value addition. Okay. Now, question number 82 talks about certain provisions of the Constitution. Constitution of India specifies minimum number of ministers that a Council of Ministers in state should have. A statement 1 is correct. Article 164 deals with this. Okay, it was brought about previously. The Constitution of India imposes an obligation to have a Ministry of Tribal Affairs on all state. Wrong statement. This is, if you people must be aware, only 4 states, Chhattisgarh, Odisha, Jharkhand, and Madhya Pradesh. Only these 4 states should have a tribal welfare minister. All other states are not mandated or obligated to do so. So statement number 2 is wrong. A disqualified member under 10th schedule. 10th schedule deals with anti-defection law. So if a member is disqualified under 10th schedule of a state legislative assembly, he can be a minister if he is re-elected to legislative assembly. So suppose a member is disqualified, he again contests election and becomes eligible to be elected as a minister, then that can be done. So statement 3 is correct. Now, fourth statement again is similar. If a member is disqualified under 10th schedule, he can be a minister if he is elected or nominated to a state legislative council. No, it was absolutely ruled by the Supreme Court and our judiciary time and again in many cases that if a particular member or individual he gets nominated to legislative council, then nominated member cannot become a minister. Okay, so that is why this statement is wrong. Coming to question number 83. United Nations declared 21 June as International Day of Yoga in 2014. That is true. Everybody knows that 21st June is International Day of Yoga. But again, ask yourself a question in these kind of questions. Why? Why 21st June? Because it was suggested that it is longest day of the year in Southern Hemisphere. Basic geography. It is not the longest day in the southern hemisphere, it is the longest day in the northern hemisphere. So statement 1 is correct while statement 2 is incorrect. Direct question. If you are aware of the fact that it is the longest day in southern hemisphere, no, sorry, northern hemisphere, you will be able to solve this question. Okay. The term public interest immunity was in news related to sealed cover jurisprudence. When we talk about public interest immunity, it is a kind of constitutional concept, legal concept. It is related to sealed cover jurisprudence. Now, when we talk about sealed cover jurisprudence, this is basically related to certain cases or certain Supreme Court related procedures where judgment or where verdicts are given in sealed cover. Okay. Why in sealed cover? In order to protect certain people. Okay. Protect people from being victimized or from being attacked by those who may be affected by that judgment. Okay. Generally, what happens? Public interest immunity, what is there? That when people are filing PIL or when people are filing case against some people, or certain corporations or certain powerful individuals, they are afraid that if the judgment or the ruling goes in the favor of public, they might face the wrath of the powerful entities or big corporations. So they should be given certain immunity. As a result, the judgment should be passed in such a manner that the identity of the person who has filed the case against big corporates and big people, it should not be revealed. So sealed cover judgments were passed at that particular time. But Supreme Court has said that if we talk about sealed cover jurisprudence, it infringes on the principle of natural justice. Okay. So as a result, this confidentiality should not be there, okay, in the justice delivery system. So it has proposed that public interest immunity should be there instead of that. Okay. Now, 85 questions is a kind of biology question, basic biology. Which of the following gland is known as biological clock of humans? It is the pineal gland. Why it is known as biological clock? Because it secretes hormone melatonin, serotonin. These kind of hormones are guiding or directing our sleep cycle, wake cycle, our routine, daily movements. Okay. So that is why it is a biological clock of humans. So rest other are wrong and pineal gland is the correct option. Okay. Question number 86 talks about Lok Sabha. Which of the following is the correct statement regarding the term of Lok Sabha? Okay. Statement number 1. The term cannot be extended under any circumstances. Okay. This is wrong. During national emergency, it has happened that the term can be extended. So this is not the first thing. Okay. Statement 1 is wrong. The term can be extended by 1 year at a time during proclamation of emergency up to maximum of 3 years. Now, again, this statement is incorrect. It is not that maximum of 3 years. It can be extended any number of time. Third is the term can be extended by 1 year at a time, any number of time. Absolutely correct statement. Okay. Fourth is it can be extended for any period of time by resolution passed by both houses of parliament. No. Article 83, if you read it word by word, you will find out Lok Sabha's term can be extended by Parliament for a period not exceeding 1 year as a time and not extending in any case beyond 6 months after proclamation of emergency has ceased to operate. So it can be done any number of time, but only 1 year at a time by Lok Sabha. Okay. Moving ahead. Nagorno-Karabakh region. It was recently in news. If you people are in, they have read about it. Again, this is a kind of current affairs questions from places in news. It is related to the conflict between Azerbaijan and Armenia. It is a border region where Armenia and Azerbaijan are involved in a conflict. Nagorno-Karabakh is a kind of landlocked place. It is a part of Azerbaijan, but population is majority Armenian. So what is happening? Tensions are increasing as the Soviet Union, like both were Soviet republics. So there is a local populace of Armenia which is protesting that we should separate from this particular Azerbaijan domination and we should go to Armenia. But again, Azerbaijan doesn't want that. So that is why this conflict is happening. So you should keep a track of all these current affair news so that any question related to places in news comes, you are able to mark the correct option. Okay. Consider the following statements regarding Indian Federation. Indian Federation is the result of agreement among states like US Federation. Like US Federation, totally wrong statement. It is not a result of agreement. Indian Federation is not a result of agreement among states because It is a not a coming together federation. It is a holding together federation. Okay. States were formed through agreement among when we there was independence given after 1947. All the state came together. All the state like agreed that will form a part of India in an integrated manner. But in USA, it is not the case. USA, there is a proper agreement in the federal system. States voluntarily come together with the union, but in India, it is not the case. They have to be part of the Union of India. States have no right to secede from the federation. Correct. In our country, we have not given states right to secede. The country is an integrated whole and divided into different states only for convenience of administration. Yes, there were a lot of committees, SK Dar committee, JVP committee, Federal Commission on Reorganization of State, which says that the division of state should primarily be based on administrative convenience and not based on any other identity in order to protect the integrity of the country. Okay. Question number 89. Which of the following privileges is enjoyed by the members of parliament individually? Now, be very attentive in reading these kind of questions. It is saying which of the following privileges are enjoyed by parliament members individually. It is talking about individual parliamentary privileges, not collective privileges. They cannot be arrested during session of parliament in criminal cases. It is wrong statement. They only cannot be arrested for civil cases and not criminal cases. Okay? Civil cases, not criminal cases. They can refuse to give evidence and appear as a witness in case pending in court during the session of the parliament. This is a correct statement. So this is a kind of individual privilege enjoyed. Look at the explanation. They cannot be arrested after 40 days. The timeline is there. And this privilege is only available in civil case and not in criminal case or preventive detention case. So statement number 1 is incorrect. Next question, question number 90. In the question given below, there are again assertion and reason kind of statements. The governor of state can reserve certain type of bill passed by state legislature for consideration of the president. Why? Because the president enjoys absolute veto over these bills forwarded by the governor. Do you think this is the correct statement? Or do you think this is the correct explanation? That governor has been given the authority to reserve the bill? No. Governor has been given the authority to reserve the bill in order to ensure that the constitutional sanctity, the authority of the state or certain institutions is maintained. That is the reason. Okay. Now coming to the next question. Question number 91. The Supreme Court of India tenders advice to the President of India on matters of law or fact. Okay. When does he tender advice? How many of the statements given above is correct? So you have to figure out this. On its own initiative, on any matter of larger public interest. Okay. If he seeks such advice, only if the matters relate to fundamental rights of the citizens. Okay. Now, in this, just it is related to Article 143. So try to find out which of these is related to Article 143. So Supreme Court of India tenders advice to the president only when he seeks advice. It cannot do so on its own initiative. It cannot do so only in the matters related to fundamental right. Okay. So this is here only statement number 1 is correct. All other are incorrect. Now, which of the following bodies are emphasized by the Constitution as bulwark of democratic system of government of India? Now, this is again a factual question. If you know about it, you will be able to solve it. If you are not aware about it, it will become difficult for you to solve it. Okay. So when we talk about bulwark of democratic system, these are institutions which are very, very essential. And these institutions are important for the governance as well as democratic running of our country. So election commission, as it holds election, it is bulwark of our democratic system. UPSC, because it relates to recruitment and employing of IAS officers, so it is important. State Public Service Commission, because it is dealing with administrative recruitment of public servants in the state level. So these three are bulwarks. Okay. Following points with regard to characteristic of fundamental duties. Now you have to figure out which of the statements are correct with respect to fundamental duties in this particular question. All of them are moral duties and there are no civil duties. This is a wrong statement. They essentially contain just codification of task integral to Indian way of life. This is correct. Codification of task integral to Indian way of life. They are extended to all persons, whether citizens or foreigners. No, they are only available to citizens. Constitution does not provide for their direct enforcement by court. This is again correct. So statement 2 and statement 4 are correct. 1 and 3 are wrong. Next question is related to preamble. Preamble of the Indian Constitution was adopted before the Constitution was adopted. It is incorrect statement. When you read the chapter on preamble, the last page you will find out the preamble was adopted and enacted after the Constitution was formulated in order to ensure continuation with the Constitution. Once the whole Constitution was made, then the preamble was adopted in order to ensure that it is in consonance, it is in synchronization with the Constitution. So if you find out this particular statement that it is incorrect, then you will come to the answer directly. Statement D, okay, or option D, right? So next is let's hold on, move on to the next question. Consider the following statements about cut motion. Now, cut motion, there are certain basic features of cut motion which are given in your book. You should be able to know that. It should relate to one demand only. Now it is correct. It can make suggestions for amendment or repeal of existing law. No, cut motion cannot make suggestions for amendment of existing laws. So it is wrong. It can be related to any matter that is charged on Consolidated Fund of India. Again, it is wrong. Cut motion cannot deal with charge expenditure, okay, because charge expenditure on consolidated fund is very critical matter. It cannot be voted upon also, it cannot be dealt with cut motion also, okay. These are certain conditions which you should go through while going through the explanation. These are certain criterias for a cut motion to be admissible, okay. The concept of economic justice has been one of the provisions of Indian or objective of Indian Constitution where it is given. So if you people must have read the DPSP, they sought to ensure social and economic democracy or social and economic justice. So there are many provisions in our DPSP which deal with equal pay for equal work, providing employment opportunities, duty of the state to promote certain industries. So this is economic justice, which is given in the directive principle of a state policy. Okay. Consider the following statements with reference to dissolution of lower house. The Council of Ministers is dissolved as soon as lower house is dissolved. Now, Council of Ministers dissolved when lower house is dissolved. Looking at this statement, you will have to figure out whether the Council of Ministers, if it is dissolved, then shall the lower house be dissolved? I would say that Article 74 is mandatory. Okay, means the president cannot exercise the executive power without the aid and advice of Council of Minister. However, again I am quote unquote, Council of Minister, if it ceases to hold office, then lower house will not be dissolved instantly. Okay, it will not be dissolved instantly. So be very attentive in these kind of questions. These can bring you some kind of confusion. Okay. So statement 1 is incorrect. Speaker vacates the office as soon as lower house is dissolved. No, not at all. The speaker is not mandated to vacate his office as the lower house is dissolved. He continues to remain in the office. Statement number 3. President may refuse to act in accordance with Prime Minister's advice to dissolve lower house if former is of the opinion that PM has lost the support of majority in lower house. This is correct. The president is bound only by the advice and recommendation of the Prime Minister, who has a majority in the lower house. So this particular statement is correct. Rest statement number 1 and 3 are incorrect. Consider the following statement with reference to Indian Council Act. Okay. Now these are details about Indian Council Act. Were given in the Indian Council Act and what provisions were not there in the Indian Council Act. Introduction of portfolio system with 6 members. Initiation of cabinet style of government. This is correct. Viceroy was allowed to overrule the council on its affairs. This was also one of the provisions of Indian Council Act. When you will go through it, you will be able to find out. Power of ordinance was provided to Viceroy. Yes, under the Indian Council Act, power of ordinance was brought about. Then further it has the centralization of legislative power by taking away the powers of Bombay and Madras. This is incorrect. It restored the legislative power of Bombay and Madras legislature. It did not curtail the power. So except for statement number 4, Statement number 1, 2, and 3 are correct. You should go through Indian Council Act and certain other legislative development during British rule. Every now and then questions are expected to be asked. Consider the following statements regarding prorogation of Lok Sabha. Lok Sabha is prorogued by the Speaker. This statement, if you have read about Parliament chapter, Lok Sabha is not prorogued by the Speaker. He can only adjourn it. Prorogation is done by the President. House cannot be prorogued while it is in session. The President can prorogue even the House which is in session. Again, incorrect statement. The House is prorogued only after completion of tenure of the government. Again, it is incorrect. Prorogation is a normal process. When Parliament is in session, after each and every session, prorogation takes place. So every 6 months, it is a very normal procedure. So it is not that the completion of the tenure will bring in the prorogation. No, this is incorrect. So none of the statements is correct in this case. Coming to the 100th question, consider the following statements about sustainable development goals. These goals have been adopted by all UN member states. Correct. It is a universal goal. All the states of the United Nations agreed to it and they want to achieve these goals by 2030. They are intended to be achieved by 2050. No, not 50, 2030. So this is a very basic and common date. Everybody must be aware of it. They are legally binding on the countries. Do you think that something like sustainable development goals will be legally binding? Because they are very comprehensive and holistic goals. And if they are being adopted by all the countries, do you think that even the smallest of countries, which are island states, the countries which are still underdeveloped, they'll be able to achieve or follow these goals, or with the resources they have at hand, they'll be able to abide by the binding legislation of, sorry, by them being legally binding? I would say this is wrong, because legally binding on the countries means they are mandated to achieve it. So this is incorrect statement. So statement number 1 is only correct, 2 and 3 are incorrect. Okay. You should go through sustainable development goals. They are a set of 17 goals. Sometimes there are possibilities that UPSC may even frame questions on sustainable development goals, the types of goals, and also about their provisions. So just go through them once before the examination. They'll be helpful in framing answers also during mains exam time. Okay. So with this, we come to the end of this session. Okay. Now, students, talking about this particular session, I have completed the whole discussion of polity part 1 and part 2. Part 1 is already available in our group. You should go through it. Now, this part 2 also will recently post it. Those who have attempted the paper and have gone through the explanation, well, good. Those who have not attempted the paper, please make sure that you attempt it, because the questions were of very good quality. They will help you out in order to get to know the trend of UPSC and also in order to revise. Basically, test series should be used for revision. The explanations which are given, the questions which are given, they will give you a good idea and they will help you in value addition also to your content which you have read. Okay. So with this, we come to the end of the session. Any question, anything related to this, any discussion you want to have, you can ping on the group. We'll be able to support you there. Okay. Okay. Have a good day. Take care.